Welkom allemaal. Ik heb even hier de link naar het rapport van de Nederlandse Bank neergezet. Ik denk als je die woorden dienstbaar aan de keten met de Nederlandse Bank googelt, dan heb je het rapport zo gevonden.
Eens kijken. Hij pakt hem hier even niet, denk ik.
Nee.
Voor de mensen die meekijken. Stop share. Ja. En share. Deze. Kijk, wat zijn ze daar? Kan je zeggen dat Nederlands ook oké is?
Oké, ja, nou.
Oké. Daar pakt hij niet. En waarom is dat?
Oké, het werkt hier.
Of degene online die...
Oké, die zien nog niks.
Nee, die zien het niet. Kijken. Bastian is klaar.
Oké.
Als je eens kijkt, als je dan het zo doet. Blijkbaar is het ergens in de... Het gaat mis als we het op grote scherm zetten. Zou je het erg vinden om het zo te doen?
Nee hoor. Oké.
Ja.
Wantadi. Welkom allemaal, live en online. Nou. Okay. I would like to talk this afternoon on legal aspects of Roman Dutch law, local law on slave trade in the period from 1634 until 1713. I'm Bastian van der Velden. I teach legal history at the Open University of the Netherlands. And in the past, I lived a couple of years on Curaçao, and there I was teaching legal history and specifically local legal history, including these themes. When we go back to find out what law was applicable on the slave trade, we have to look into the first document mentioning trade in the West Indian Company, who was responsible for the trade in the West Indies. In the 1629 constitution made by the States General for the West Indian Company, there was an article number 61 which said that de gemene beschreven rechten, it's mean, no it's not mean, it's the written Roman law will be applicable on trade transactions in the territory of the West Indian Company. This is 1629, so it's before Curaçao was occupied by the West Indian Company, and it's also long before slave trade became cornerstone of the enterprise. And when we look into the sources, we see, for example, here from 1676. I found it today and I was very happy to discover it. A source by a jurist on the Roman Dutch law saying that in the West Indies, the gemene rechten, so this Roman law, was applicable. Then he says that it's maybe not the best trade to have, but it is the applicable trade. That was on the next page. Very interesting is this source. I also found today this digitalization of sources is really going very, very fast. So small details you couldn't find for 10 years can be traced now when you at least have an idea what you're looking for. This is a letter by the directors of the Berbice company, so the Berbice we were talking about before. to the states of West Friesland and Holland. And they are discussing the Roman law applicable in Berbice. And what are they saying? Roman law is applicable. The Roman law was never stopped, made, yeah, it's still in function. But when we look at the facts, we can only see that in important fields, the Roman law is not followed. And then there comes really a detailed account of Roman law on the way slaves should be treated. And this director, it is Mr. Hartling. He's also the author of some very important books on that region. He explains that according to Roman law, it's very interesting, there is a big difference in law with regard to slaves. So Roman law is a set of legislation made between the year 800 BC until 600 after Christ. So this is over 1200 years, and you can imagine that in these 1200 years there is a big difference in towns, Rome itself, other big towns in Italy where slaves were living and how the relations with their owner was, plantations and how their slaves and their owner's relation was. So you cannot talk about Roman law in general. What was applicable in the Netherlands was the Roman law as codified in the codification of Justinian, or the Corpus Juris Civilis. And what is this Hartling saying? When I look at Roman law over this long period, I see differences in the way slaves were also a little bit protected by the law. But here in Berbice, no one is following this protective side of the slaves. There are rules that someone who murders a slave is accountable like he's murdering a normal person. In Berbice, at least towards slaves, every behavior was allowed. So then he comes with food at the end, saying it's quite clear that laws which are not followed by the court, by the citizens, get into destitute and in the end are de facto annulled. That was Berbice, but I want to know more about Curaçao, Aruba, and Bonaire. And I had to find a solution. Studying Roman law is even today quite easy. The Corpus Juris Civilis has been translated into Dutch and English, so in every language you can read this source. But what happened on Curaçao exactly was, of course, not written down, and there are not so many court documents. So finally, I was very happy to find also an important source for South Africa. South Africa was like Berbice, occupied by the English in the Napoleonic Wars, and the English legal system is the common law, and in the common law, there's a high respect for previous older legislation. So in South Africa, they didn't introduce UK law when they occupied the territories, but they continued the Roman Dutch law as it was applied there already for a couple of hundred years. And the English simply asked the fiscal, the highest jurist of the Cape, to write down a report on the applicable law on slaves and slave trade. So this document, of course, is a little bit different de facto, because the Cape was part of the East Indies. and had local laws which can be different from Curaçao or Suriname, but at least it gives us a good direction what they considered the Roman Dutch law, extramuros, in that period. When we go back to Roman law, the sale of enslaved people was very in a very detailed way regulated. The slave sellers in Rome were not the most appreciated merchants. They were crooks. They were considered really the lowest in town. And the judge who had to deal with these guys was the overseer of the markets. The aedile had to solve all the disputes between the slave seller and the buyer of slaves. And he introduced a detailed system of ways the seller had to guarantee certain qualities of his merchandise. Even the legislation nowadays applicable on the sale of goods to consumers can be directly traced back to this legislation. So the aedile made an edict, a sort of law applicable for his territory where he was responsible, and they introduced two important categories of defects. On the one side, the morbus, physical defects and diseases, and vitium, defects due to poor mental state or a rebellious enslaved person. And the seller was obliged to give all details on these characters of the enslaved people he was selling. Of course, certain characteristics you could directly see when someone was missing an arm. He was not obliged to state that. But when the seller was, for example, by using makeup, trying to hide certain things, he was liable for that. So all these guarantees had to be given or followed from the fact that he was simply selling them. What kind of physical defects did he have to mention? Well, diseases on the lungs, liver, gallbladder, other chronic diseases, epilepsy, they're all mentioned into detail. The lack of genitals, inability of a woman to bear children should all be mentioned by the seller. And for the character of the slaves, he had to mention whether they were superstitious, had a tendency to gamble, to drink, to stare at masses. So a whole lot of things he had to place on a big placard, a table, when he was selling a person. And when he didn't tell every detail, he was liable for tort. And in the end, he had to take back the enslaved person and pay back the sale price. So keep in mind that in the Roman law, the seller had to guarantee quite a lot on the physical defects and psychical problems. Keep that in mind, we come back to it later. On Curaçao, things were a little bit different. For many countries here in the Caribbean, we know about the Code Noir. So that was in Spanish territories, in French territories, a specific code for the way enslaved people should be treated. In the colony of Curaçao, Bonaire, Aruba, such a thing never existed. We know that, for example, there are in the whole history you find little traces. So when we go and read about the history of Curaçao, we read about slaves selling in the streets things, and they could apparently keep the profits for themselves and had to pay to the owner once in a while a certain amount. There were even documents that they could rent houses and own enslaved people on their own. For many historians, this is quite a miracle. For Roman law specialists, this is simply the application of the peculium. So it's always important to know the law and then to interpret what you're seeing, and not to say it's a strange thing, it's a real thing, how can this happen? Because the Romans already thought about it and were very, clever with it. So when we go to the sale of slaves, I was wondering, how was the sale of slaves on Curaçao organized? We don't have many documents on it. Of course, many were sold illegally to the main, and no one knows anything about it, and you cannot go to court about that. But the most of the enslaved Africans were sold on Curaçao under the asiento. The asiento was a contract made either in Amsterdam or in Cadiz in Spain. And this contract made it possible for the West Indian Company and other subcontractors to sell slaves from Curaçao to the Spanish main. There was a big need of enslaved people in Venezuela and other countries, and the Dutch were providing these labor. But I told you, the West Indian Company was responsible for this sale. Roman law was applicable on Curaçao, but as a seller of enslaved people, you had to give a lot of guarantees. Of course, the West Indian Company could adapt the law, but they did not do so in a law or a bylaw. But I was still puzzled. I thought it's not logical that the West Indian Company is selling on Curaçao or in Amsterdam, but a delivery on Curaçao to the main enslaved people under Roman law. It doesn't make sense. Although it's in this constitution from 1629, I would not advise my boss to do so. And we see in the history that there were a series of subcontractors in the period from, let's say 1640 till 1713, and I stopped in 1713 because that is the day of the Treaty of Utrecht, and from that date the English took over these asiento contracts for the delivery of enslaved people to the Spanish colonies. And we see that, there are a couple of subcontractors. When you look at the contracts, you see that these contracts are completely standardized. It's not about people, it's not even about enslaved people, it's about pieces. It's simply about 400, 800,000 pieces, and a piece is one male enslaved person, and a woman is 3/3 of a piece, and a child is half a piece. We see here also that here I only have mentioned the numbers in the contracts, and we see that it's really a large number. But what happened? The West Indian Company, it was not very logical to sell under Roman law. And finally, I was very happy, I saw my idea back in one of the contracts between the West Indian Company and it's here below. This is from 1690, glaube 80. And what do we read there? When there is a problem, we do not go to court. In this contract between the West Indian Company and the Spanish king, there was a simple solution. When we have a problem on Curaçao, on the quality or the number of enslaved people sold there, we go to Amsterdam, 2 people from one party, 2 people from the other party simply discuss as gentlemen the problem to find a solution. We do not go to court, definitely not on Curaçao, because there the outcome was already known most of the time, because the court was simply the same as the governor and 3 of his people. So here we see that although we have this constitution and the clear mention of Roman law, you have to first research Roman law, then look at the facts to see whether it makes sense or not, and then search and search and search, and finally you find the source where everything becomes much more logical, namely that you do not go to court, but try to find a solution as gentlemen. These slave traders apparently could be gentlemen. But to come back to the course of Viola Hoytker, this is a system which is even today still completely normal and a part of international trade law. In the UNIDROIT Principles for International Commercial Contracts, a sort of instrument you can choose, you can opt in, which changes every year, so I don't mention now the exact year. There is a special rule even today that when there is a certain something like now the corona happening and all the circumstances change, you do not go to court. Before you can go to court, you must renegotiate. So you have to sit around the table with each other to try to find a good solution. And also in most of the international trade contracts, the drafter will always put such a clause for any problem, because in general it's much faster, it's cheaper, and you know the outcome. When you go to court, you never know the outcome. So here we see that this principle used by the West Indian Company is still playing a big role in modern international trade law. And with that, I think I'm coming almost to the end of my story, but I hope there are maybe questions. Yeah.
I noticed that it's something like you can compare slave trade with car trade because the seller of the car has to guarantee the quality of the car, and if there are hidden things that the buyer doesn't know, the seller is responsible. Was there also something like an official checklist, or was there something like an registration where slaves have numbers, or that were officially registered, like cars are registered nowadays? Or is it just man, female, child, general?
The numbers were so unimaginable that they had this simple system saying one man in the age of 20 to 40 is counting for one, this woman for 3/3, children for
Half.
half.
Yeah.
And on Curaçao, there were, let's say, on the Asiento is still a place in the middle of the island where the name is still surviving. There the people who could be delivered to the Spanish territory were put together, and then there were outside the city some places where they tried to revive or to put together people for a while because they thought, hey, we cannot sell them. But in general, you see that they promised very high numbers and quite often were not able to deliver fully.
I would like to ask something about the hereditary character of slavery in at least in Curaçao. Is that a continuum from an earlier stage of the judicial system, or who came up with that aspect of slavery? What I mean is that if a female person under the law is a slave, all of her children will automatically be born as slaves of the same owner. That's what I mean.
That is already a Roman law principle.
Yeah.
And so that you can trace back. And I think that is also one of the most, let's say that here you see law really at its most formalistic way. Even the word enslaved for me gives the idea that someone was taken somewhere and put on a ship and then sold. But here you see that the child in the womb, not born yet, is already owned by the master, by his father. When this father goes bankrupt and the estate is sold before the child is born, the next owner will become the owner of these children of this slave owner, and he must try to buy them back in a certain way whenever it is possible. So there you see that it's completely a legal system, and not only, of course, also a mental system, also, let's say, physical, but also legal. When you look at the town of Maarsen, I don't know whether you ever went to Maarsen, where it's a little village near to Utrecht. They have all their notary deeds online with many sales of slaves, because whole plantations were sold there from one person to the other, including the slaves. So the idea of the Roman Dutch lawyers from the 17th, 18th century that slavery didn't exist in the Netherlands, and so this part of the Roman law was not applicable in Holland, is nonsense. And you, luckily, because all these documents are now very easily accessible, you can trace this in in minutes.
Did you come across any ethical problems by the slave sellers or transporters? Was it just trade?
It's, let's say, it's quite difficult. It's history. No, I mean, it's history, so it's the period from, let's say, 1600 until 1863. And of course, in this period, you see also in the legal sources different opinions. So in the beginning, it was big fun to seize or to make people free who were owned by Spanish merchants who came to Antwerp or to Zeeland and say, ha, you cannot have enslaved people in the Netherlands, so these people are free now. When the Netherlands had this big system, 1713, there was a case at the Hof van Holland en West-Friesland in The Hague, where someone from, I think, Curaçao, but maybe Suriname, was taken with his owner to Amsterdam. And in Amsterdam, he said, well, there's no slavery here, so I'm free now. He went to first to the Raad in Amsterdam and then to the Hoge Raad in The Hague. And there they said, yeah, when we look at Roman law, you're free when you're in another kingdom. But the West Indies and Amsterdam is the same kingdom. So we cannot apply this rule. The same thing happened in 1830. Van Raders, a governor of Curaçao and later governor general in Suriname, took one of his slaves to Amsterdam. The lady was from Curaçao, and he said, you're not good. I'm going to send you back to Suriname. And then this poor girl really got, what should we do? So she went to I don't know where she exactly went, but the case was discussed by the Dutch Ministry of Justice. And there you see that they said, this guy should know better. We now have the Civil Code. Article 1 of the Civil Code says that everybody is free. He is a very respectable citizen, but now he's going too far. So then the girl was sent back to Curaçao in the end. And he, even when you read all the archival material, you see that they saw the problem, but it is quite late.
More questions?
Nog op de internet kan jij kijken?
Nee, er zijn geen questions.
Okay.
We spoke about a contract that stated that they couldn't work, right?
Yeah.
Yes. So you also said nowadays you also go to before going to court for this kind of last resort. But why in that time period it was like stated that you couldn't go? Was there a specific reason?
Well, the first reason is that, of course, when the court had applied this Roman Dutch law, the seller, the West Indian company, had to give far too many guarantees. They were not willing and not able to give. So for me, that was sort of a thesis. Facts. I thought it cannot be that they sell under Roman law, although it's in the Constitution of 1629. So then I had to find a solution. But you have to find the solution in the sources, of course, not only in my head. And then finally, I found these documents where they had this, gentleman's solution, so to say. And there you see that this not going to court, find a solution between the parties is still part of international trade law today. So it's also not so weird what they are doing. But with regard to slaves, it was also, I think, the only possible solution for them.
So it is look like that the Pandora box of the West Indies company is open for research.
Absolutely.
There is still a lot of research to be done.
And the interpretation of documents and written information and the might be oral history of the colonized islands.
Oral history, news, not news sources, but simply that all these books from this period are now available, digitalized. Many notary deeds and all this material is now very, very accessible. That in Amsterdam, they're really focusing on the former colonial history to make this material also accessible for people all around the world, and not only for people who are living in Amsterdam. The subjects are changing. So, for example, when I started my research in 2006, no one was talking about the Afro population of Amsterdam in the 17th century. Everybody knew these nice paintings by Rembrandt, but these were paintings, and now they try to put a name on these people, try to identify how their social structure was functioning in Amsterdam. And then you see, for example, by looking at the what is the dope, the baptism records, then you see that a woman from this circle has a child, and that 3 or 4 other people from this community are the pater and the mater. So they are attending this ceremony, and you can really trace back how financially these people helped each other because they lived in the same houses, they lived in the same area. And I think that is very interesting to see that simply by posing yourself other questions. When I started the research, for example, one of the things which irritated me was that within the slave communities, there was no judge, no court, no justice, no system of law. But from my professor in sociology and law, I had learned in the first lesson that in Israel, in the 1940s, there were certain, let's say, farms which were called Curaçao and the other Moshav, and they had different property ideas on property. And due to this fact, they also had different internal court systems. Let's say it was not a real court, but within the society, some men acted as a court. The whole thing existed maybe 10 years, and there was a court. There was no law there, let's say written law, how it should be organized. Everybody found a way solving problems. Now that's all outside. And then, but what happened then here on a big plantation, or in Willemstad, or here in Aruba? It really took me 3 years until I found some sources about election beer. What was election beer? In the United States, when there were official elections for the president, Black communities, even enslaved people, had their own elections for a chairman, a justice, and a guy to organize the festivities. And he made this election beer. So then I had the concept, I grabbed it, but was not yet happy because I wanted to have it closer to the Caribbean. Then I found from English churches who were sent in the 1820s to Jamaica. They apparently had nothing to do there, but they wrote thick books about what they saw because they were diving in new society. They didn't know what was. They described court cases on the plantation where there were some elder men acting as judge. A guy who was able to speak very well was a lawyer for one side, and the other also had an advocate. In this society of enslaved people. Interesting is that these lawyers are traced down later to the first Afro-Jamaican politicians. So there is a direct trace between these people able to talk in public and the first politicians.
But making that as an example, it sounds like the indigenous law, because nowadays, the academic world shows that indigenous law is also a law by the indigenous. So those enslaved person in this atmosphere in Caribbean, North America, they get used to that Rome law and make their own law squeeze into the Rome law, or we can see that also as an indigenous law?
No, we are at least quite sure that when you can, they couldn't take material objects from Africa to the Americas, but they were able to take with them all kinds of immaterial things. The way to grow food, the way to prepare food, language, religion, all aspects. I cannot say they're from that little town in Africa, but you can really trace it, the whole line, and how it still plays an important role here on the island, on Curaçao, and the rest of the Caribbean. And for me, it was the most important.
But also in the mainland.
Yeah. And for me, as a, let's say, a law professor, the most important was that I had my class and didn't want to say, okay, 1634, the West Indian Company came, blah, 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 and that's it. I had a class with people with Afro-Curaçao background, Jewish background. Here, maybe also Amerindian background. And I wanted to give them all a chapter in the book so that they could think, okay, when I read this book, it's also my history. I think that is for the history the most important. Whether I can put the line until 2022, that's maybe more for sociologists. For the historian, I think it's important to give everybody the idea that they are part of the history on the same level, and not like many people before me who wrote about the legal history of the Caribbean, saying within the Afro enslaved communities there was no law, there was maybe punishment by the owner, but that's it. Who said maybe there were Indians, but they didn't have law, or maybe they had, but it's not worth writing about it. I think we should try to say something serious about it. Maybe only a couple of pages, but not discharging it because it's not this nice published book.
Okay, thank you very much, Bastian, and thank you for our audience to be with us online. It was really fantastic to listen to both of you.
Yeah.
Really to have a vivid idea of how this trade was organized, and also from a legal point that it's not only the applicable law, but there's so much more. There are contracts, there are customs, and there's these international relations like this ASEAN, like an international convention, and also legal pluralism, one law next to another. So we had, within the enslaved people traditions, within the Jewish community, so very full. It's not only one law for all, and that makes it also so interesting to go on with this research.